Recording in progress.
Namaskar and a very good evening to all. On behalf of Akhil Bhartiya Adhivakta Parishad Devgiri Prant, I warmly welcome to all the participants to today's fourth lecture in this valuable series for the District Judge and Judicial Magistrate First Class Civil Judge Junior Division Examination Preparation. We are privileged to once again have with us our esteemed speaker, Shri Sandeep Dnyanoba Munde sir. Sir is presently serving as Deputy Registrar Group A at the Maharashtra Administrative Tribunal, Aurangabad bench, and has secured first rank in Maharashtra through MPSC for this prestigious post. He has rich experience in legal practice before the Bombay High Court Aurangabad bench and has been guiding aspirants in the subjects like Civil Procedure Code, Administrative Law, and Jurisprudence. Sir's previous lectures have been extremely insightful and beneficial for all the aspirants. We are confident that today's session will further strengthen our understanding of the Civil Procedure Code. Now I humbly invite Shri Sandeep Munde sir to deliver the fourth lecture on the Civil Procedure Code. Thank you. Sir.
Thank you, sir. So, good evening to all. In the last lecture, we have tried to conclude up to the order 7, that the plaint. As we have already discussed the stages of the suit, till the filing of the suit, after filing of the suit, the proper presentation of the plaint, it will be registered as a suit. So, in today's lecture, we will discuss the further stages of the suit. After the presentation of the plaint, suit will be registered. Thereafter, the issuance and service of the summonses to the defendant. And after that, after causing appearance by the defendant, what are the next stages for the defendant? So, after causing appearance by the defendant, the next stage is to filing of the written statement. When the written statement has been, after the appearance by the parties, the written statement is required to be filed by the defendant. So, the order 8 deals with regards to the written statement. So, what the order 8 will state? Order 8 deals with regards to the written statement, set off, and the counter claim. So, in today's lecture, we will start with the order 8 written statement. So, in the definition clause, we have already discussed what is the concept of written statement. Though in the section 2, there is no definition of written statement has been provided. But what is the definition of written statement? Written statement, it is the reply of a defendant to the plaint filed by a plaintiff. So, in order 6, in rule 1, we have already discussed what is the concept of pleading. Pleading means plain or the written statement. In last lecture, we have discussed what are the necessary ingredients for the plaint. So, in today's lecture, we have to discuss what are the essential ingredients for the written statement, how the written statement is required to be drafted, and what are the essential things for the written statement. So, in the simple words, written statement is a reply of a defendant to the plaint filed by a plaintiff, and it is the pleading of a defendant dealing with the every material fact of a plaint. So, there will be the MCQ type questions with regards to it, that within how many days it is required to file the written statement. Within a period of 30 days from the date of service of the summons, defendant is required to file the written statement, and the court has power to extend the said period not beyond 90 days from the date of receipt of summonses. Along with the written statement, in the order 8, we have to discuss two other concepts. That the second one is the set off. Rule 6. Set off, it is the concept which is applicable in the when the suits are with regards to the money suits. When it is regards to the amount, when it is regards to the money claim, then the concept of set off is relevant. And the third concept is the counter claim. As we generally use the word in the criminal cases that the cross case or the cross complaint, the counter claim is nothing but it a cross suit filed by the defendant against the plaintiff, and to that all the entire rules of the order 7 with regards to the plaint is applicable to the order 6, order 8, that is the counter claim. So now we will firstly discuss the concept of written statement that is given under order 8. So friends, the rule 1 of the order 8 deals with regards to the written statement. Order 8 heading is the written statement, set off and counterclaim. The written statement, the defendant shall, within 30 days from the date of service of summons on him, present a written statement of his defense. Whatever the defendant wants to raise his defense to counter or to file against the plaintiff's claim, he may file within a period of 30 days from the date of service of summons upon him. Provided that that period can be extended, but it shall not be later than the 90 days from the date of service of the summons. It has been stated in the rule 1. What is the rule 1A? Duty of the defendant to produce documents upon which relief is claimed or relied upon by him. So, as like the plaint, whatever documents relied by the defendant is required to be produced along with the written statement. Rule 2, no facts must be specially pleaded. Apart from the defense, if you want to raise the new facts in your written statement, it shall be pleaded specially. Rule 3, 4 and 5. It is the concept with regards to the denial to be specific, evasive denial, specific denial. As per the requirement, as per the allegations made in the plaint, whatever you are denying, whatever your contents with regards to the said, you have to deny it. It should be the specific, it should be the specific denial, and it should not be such a vague type. It should be clearly stating that, yes, I am denying the said thing. As per the rule 5, sub-rule 4, whenever a judgment is produced under this rule, the decree shall be drawn up in accordance with such a judgment, and such a decree shall bear the date on which judgment was pronounced. So, if in exercising the discretion, if any allegation made by the parties and where a defendant has not filed a pleading, it shall be lawful for the court to pronounce the judgment on the basis of the facts contained. One question with regards to the order 8 is that whether the filing of the written statement is a mandatory in nature or in the directory in nature. After the receipt of the service of summons, whether it is a mandatory upon the defendant to file the written statement or it is in the directory in nature. If the party defendant not coming before the court of law, not filing of the written statement, then the court will wait for it? No, court will proceed further, and as per the contents raised in the plaintiff, court may pronounce the judgment. So this 1 to 5 deals with regards to the written statement. Now the rule 6 states with regards to the set off. Particulars of set off to be given in written statement. It reads, where in a suit for the recovery of money. In which suit the concept of set off is applicable? It is applicable when the suit is for the recovery of money. The defendant claims to set off against the plaintiff's demand any ascertained sum of money legally recoverable by him from the plaintiff, not exceeding the pecuniary limits of the jurisdiction of the court. Consider there are the two plaintiffs, A plaintiff and D is the defendant. Plaintiff filed the suit against the defendant for recovery of money of rupees 1 lakh. And defendant set out the claim that I have already paid you the 70,000, only the claim of 30,000 remains. It amounts to the set off, and concept of the set off is only applicable in the money suit. When to file the set off? Set off or the counterclaim is required to be filed along with the written statement. If it has not filed along with the written statement, permission of the court is required to file the set off or the counterclaim. And in the written statement, it is also required to be stated that for the purposes of the said, separate set off or the counterclaim has been filed by the defendant, claiming the reliefs against the plaintiff. So, Sub-Rule 2 states, what is the effect of set off? The written statement shall have the same effect as a plaint in a cross-suit. So, whatever the provisions of plaint will be applicable to the set off, because set off has a same effect as like the plaint. Now, by virtue of the amendment of 1976, this Rule 6A to 6G has been inserted, which states with regards to the counter claim. If the plaintiff files the suit against the defendant and defendant also wants to file the suit against the plaintiff, no separate suit is likely needs to be filed with the same cause of actions or the different cause of actions. If the defendant wants to claim the relief against the plaintiff, he may file the counter claim along with the written statement in the said suit. So, to avoid the further complications, to avoid the multiplicity of the litigation, this has been inserted by virtue of the Amendment Act of 1976. Counterclaim by defendant. A defendant in a suit may, in addition to his right of pleading, a set off under Rule 6 set off, by way of counterclaim against the claim of the plaintiff, any right or claim in respect of a cause of action occurring to the defendant against the plaintiff, either before or after the filing of the suit, but before the defendant has delivered his defense or before the time limited for delivering his defense has expired, whether such counterclaim is in nature of a claim for damages or not. So, this Rule 6A has been inserted that defendant will be in a position to file the counterclaim against the original plaintiff for the purposes of claiming the reliefs against the plaintiff. Be counterclaim to be stated where any defendant seeks to rely upon any ground as supporting a right of counterclaim, he shall in his written statement state specifically that he does so by way of counterclaim. Exclusion of counterclaim, when it excludes the pecuniary limits or the any other limits of the court, then the counterclaim can be excluded. Effect of discontinuance of the suit. 6D, it will be the question with regards to the multiple choice question that what is the effect of the discontinuance of the suit? Suit has been filed, along with the written statement, counterclaim has been filed. If the suit has been discontinued, what is the effect of said Rule 6D states, if in any case in which the defendant sets up a counterclaim, the suit of the plaintiff is stayed, discontinued or dismissed, the counterclaim may nevertheless be proceeded with. It gives the answer with regards to the said question. Default of plaintiff to reply to the counterclaim ex parte. Relief to defendant where counterclaim succeed, as like the plaintiff, he will be entitled for the same reliefs. Whatever the rules with regards to the written statement will be applied to the written statement to the counterclaim. 7. Defense or set off founded on separate grounds. Where the defendant relies upon several distinct grounds of defense or set off or counterclaim founded on separate or distinct facts, they shall be stated as far as may be separately or distinctly. In short, there should not be the complexities with regards to the said. If it is on different grounds, it is on separate grounds, it can be stated separately. New ground of defense can be stated in the said. Subsequent pleading. As like the plain, no subsequent pleading has been permitted. No pleading subsequent to the written statement of a defendant other than by way of defense to set off or counterclaim shall be presented, except by the view of the court upon such terms as the court thinks fit. If you want to state the set off or the counterclaim, it is required to be stated along with the written statement, and no pleading subsequent to the written statement with regards to the said is allowed by the court. The last rule, procedure when the party fails to present written statement called for by the court. Where any party from whom a written statement is required under Rule 1 or Rule 9 fails to present the same within time permitted or fixed by the court, as the case may be, court shall pronounce judgment against him or make such order in relation to the suit as it thinks fit, and on pronouncement of such judgment, decree shall be drawn up accordingly. If the party fails to file the written statement on the basis of material available on record, court will pronounce the judgment. So, what is the crux involved in the order 8? Written statement, set off, and the counterclaim. These are the three concepts under order 8. Written statement, it is the reply filed by the defendant to the plaint filed by the plaintiff. Written statement is required to be filed within a period of 30 days from the date of service of summons. Whatever the written statement has the pleading, whatever the rules of order 6 pleadings generally are applicable to the written statement, it should be in the conscience form, it should be with the specific denial, it should be with the specific format. In addition to the written statement, if it is a suit with regards to the recovery of money, the concerned party may file the set off against the plaintiff, and if it for the other things, defendant may file the cross suit or to counter the suit filed by he is liberty to file the counter claim along with the filing of the written statement. These are the provisions with regards to the written statement, set off, and the counter claim. Now, moving further, what is the next order? Order 9 deals with regards to the appearance of the parties and consequences of the non-appearance of the parties. In the simple words, I generally state this order as the Hazir to Wazir. Whoever will be present before the court, he will get the relief. Who is ignorant to his rights, who is not coming before the court will not look for his rights. Court will decide the case ex parte, or if the plaintiff remains failed to appear, court will pass the order with regards to the dismiss in default. So, what are the concepts involved under Order 9? The title of the Order 9 is that appearance of the parties and consequences of non-appearance. In Order 9, there are total 14 rules are involved, in which the major portion covered with regards to the appearance of the party. We know there are only two parties, plaintiff and defendant. Second, whether neither party appears, both of them remains present, what will be the consequences? Where only plaintiff appears. Next, where only defendant appears. Where summons is not duly served. What is the concept of ex parte order? What is the concept of dismissal for default? So, in short, I will conclude this order in such a way. Appearance of parties and consequences of non-appearance. If both the parties remain present, matter will proceed further on the merits of the case after completion of the pleading, because we have already filed the written statement according to the order 8. Now the pleading has been completed. If both the parties remain absent, it is the duty of the plaintiff. Plaintiff presented the suit, he has to take care, he has to proceed with the suit. If both the parties are absent, court will pass the order of dismissal in default. If only plaintiff absent, court will pass the order of dismissal in default. And if the defendant remain absent, court will pass to proceed ex parte against the defendant. These are the only crux involved in the order 9, which states in the different 14 order. So, again, what are the consequences of non-appearance? I have told you. If the plaintiff not appeared, DID. If the defendant not appear, ex parte. In the said order, it has been also given remedy or the reliefs if such orders have been passed. What are that remedies has been given? Plaintiff may file the application for setting aside the dismissal order passed under the order 9, as well as if the ex parte order has been passed, defendant may apply before the same court by filing the application for setting aside ex parte order. So, the rule 1 and 12, parties to appear on the day fixed in summons for the defendant to appear and answer. 2. Dismissal of suit where summons not served in consequences of plaintiff's failure to pay the cost. According to the order 7 rule 9, when the plaint being admitted, within 7 days he is required to give the copies of plaint as well as the requisite fees. If he fails to it, court will dismiss the plaint. Where neither party appears, suit to be dismissed. Both are absent, suit will be dismissed. 4. Plaintiff may bring fresh suit or court may restore suit on file. If for the failure of the plaintiff he not present, he is not barred to file of the fresh suit. He may file the fresh suit or may file the application for the restoration of the said suit, because if he convince the court that for the reasons best known to him he may not present, then court will consider. 5. Dismissal of suit where plaintiff after summons written answered fails for 7 days to apply for the fresh summons. It is the technical also. The plaintiff is required to do the compliance. Procedure when only plaintiffs appear. Court will check whether the duly summonses has been served upon the defendants or not. If it has been presumed that, if it has been shown that yes, it has been duly served, court may make an order that the suit shall be heard ex parte. When summons not duly served, court will again second summons to be issued and served to the defendant. When summons served but not in due time, not the appropriate time not getting to the concerned defendant, court will adjourn the hearing and consider it on the next date. 7. Procedure where defendant appears on the day of adjourned hearing and assign good cause for the previous non-appearance, court will set aside the ex parte order and proceed to merit. Procedure where defendant only appears. If only defendant appears, court will dismiss the suit. Decree against the plaintiff by default bars fresh suit. Now, according to the order 9, rule 9, it bars the fresh suit. The bar to further suit. According to the section 12, if there is also example of order 9, rule 9, decree against plaintiff by default bar fresh suit. Where a suit is wholly or partly dismissed under rule 8. Under rule 8 means only defendant appears and the plaintiff not appeared. Plaintiff shall be precluded from bringing a fresh suit in respect of the same cause of action. But the bar has been created to file the fresh suit, but he may apply for an order to set aside the dismissal aside, and if he satisfies the court that there was a sufficient cause for his non-appearance, when the suit was called for hearing, court shall make an order setting aside the dismissal upon such term as the cost or otherwise as it thinks fit. It not create the bar for filing application for setting aside the ex parte decree. 10. Procedure in case non-attendance of one or of the several plaintiffs not required. One may be 11 and 10 and 11. 12. Consequences of non-attendance without sufficient cause shown of party order to appear in person. If the court directed to appear to the parties may be plaintiff or the defendant, and if he didn't appear, the court will pass the appropriate order. The last 13, setting aside decrees ex parte. If the setting aside decree ex parte against the defendant, he may file the application according to the order 9, rule 13, and court will consider on its own merit. The last rule 14, no decree to be set aside without notice to the opposite party. These are the principles of natural justice. If you want to set aside the decree passed the ex parte, both parties are required to be heard. After giving the notice to the parties, it can be set aside. Now, the next stage that the order 10, the heading of the order 10 is the examination of parties by the court. So, it is the stage in which in order 10, there are total 4 rules are there. Until now, we are discussing the provisions only to the extent of what are the duties of the plaintiffs, what are the duties of the defendants, what is the stages of the issuance of summonses, what are the modes of service of summonses, what are the rules of the pleadings, what are the rules for the drafting of the plaint, what are the rules for the drafting of the written statement. Only the court has issued the notice under order 5. Only the court has issued the notice under order 5. Till now, court has not looked into the pleadings of the parties. So, the order 10 gives first date, it is the first hearing date according to the order 14. What is the first stage? There is the difference in between the stages and the first date of hearing. Which date will be treated as the first hearing date? So, the day on which the court goes into the pleadings of the parties. What is meant by the first hearing date? The day on which the court goes into the pleadings of the parties in order to understand their contentions. It is the first date of hearing. The first stage is the presentation of the plaint. Second stage is the filing of the written statement. And the third stage is the framing of the issue. Prior to the framing of the issue, court looks into the pleadings of the parties and examine the parties in order 10. That is the heading, examination of parties by the court. Ascertainment whether allegations in the pleadings are admitted or denied. Rule 1A, directions of the court to opt for any mode of alternative dispute resolution. This 1A has been inserted by virtue of Amendment Act of 1999, and in which it has been stated the court may give the options to the parties of ADR, alternative dispute resolutions, whichever mentioned under subsection 1 of section 89. So, by virtue of arbitration, conciliation, mediation, settlement through lok adalat, all the parties may be directed to be remain present before the said forum according to the 1B, appearance before the conciliatory forum or authority, appearance before the court consequent of the failure of efforts of the conciliation. If it has been said, if it has been succeed, no problem. If it has been failed, the file will be returned back to the court for the fresh consideration. Oral examination of party or the companion of the parties, substance of examination to be in writing, consequences of refusal or inability to of the pleader to answer. Court will direct the party to be appear if the pleader is not in a position to give the answers raised by the court. So, according to the order 10, first time court will look into the parties, pleadings of the parties and ask the parties to go for the, as per the provision of section 89, for the ADR, alternative dispute resolution. And then after court will look, court will see whether the allegations made are in such a way that it can be compromised, it can be settled, it will be settled before the conciliatory forum. If it's not settled, file will be back and court will decide it on own merits. Order 11 deals with regards to the discovery and inspection. The provisions of 30 and 32 also deals with regards to the discovery and inspection. If anything is as in such a way which has not been given, the parties have a right to ask by the interrogatories. The opposite party may ask to the opposite party to give that document on record or to produce that document on record. That is not, no any such type of question has been asked on the order 11. So I will skip order 11 for your convenience. You may read it. Now, moving further, order 12. So what is order 12? Order 12 heading is the admission. As I have only the consist with the earlier Evidence Act, Section 58 of the Indian Evidence Act deals with regards to the facts admitted need not be proved. What I have stated, according to the Section 58 of the Indian Evidence Act, heading is that facts admitted need not be proved. If anybody is admitting the fact, it means parties will not be at issue and that there will not be a dispute. So, Order 12 is based upon the same contention that it is the concept of admission. Notice of admission of case, notice to admit documents, documents to be deemed to be admitted if not denied after service of notice to admit documents, form of notice, power of court to record admission, notice to admit acts, form of admission, and Rule 6 is the important that deals with regard to the judgment on admission. Where admission of fact have been made either in the pleading or otherwise, whether orally or in writing, court may at any stage of the suit, court may at any stage of the suit either on the application of any party or of its own motion, and without waiting for the determination of any other question between the parties, make such order or give such judgment as it may think fit, having regard to such admission. And whenever a judgment is pronounced under sub-rule 1, a decree shall be drawn up in accordance with the judgment, and the decree shall bear the date on which the judgment was pronounced. If the party is admitting, yes, whatever the claim made against me, I have admitted, the court will not court will not proceed with the merits of the case. If the parties are admitting, according to the rule 6 of the order 12, the court may pass the judgment on the basis of admission. Affidavit of signature, notice to produce document, and the cost. These are the some of the rules in the order 12. Next stage will come if there is the admission by the parties and court pass the judgment, no further process of coming in the picture of order 13. But if there was no admission, then the next stage of the suit that deals with regards to the production of the document. In order 3, again there are the three concepts. First concept is the production of document. Second is the impounding of document. And the third one is the return of document. If you see the literal meaning of these three words, production means to produce the documents. Return means to return, RETURN, ज्याने दिले त्याला वापस द्यायचे, to return the document. And impounding means to impound, to seize the document. If that document, the court found there is the infringement of any law, it is the meaning of the impound is that seize and take the legal custody, something specially a vehicle, goods or documents because of an infringement of the law. If it is found the document has been produced on record and court, it is found that the document has been infringement of the law, then the court has a power to impound that document. Rule 1 states original documents to be produced at or before the settlement of issues. The parties, what the word has been used, parties, it is applicable to both plaintiff as well as defendant. The parties or their pleader shall produce on or before the settlement of issues. What shall they produce? All the documents, documentary evidence in original. All the documentary evidence in original. Here the copies thereof have been filed along with the plaint or written statement. In the plaint, we have discussed the documents to be relied has to be mentioned in the plaint and the copies are required to be given along with the plaint and the written statement. So whatever the documents has been produced, all such documents are required to be produced prior to the framing of issues before the court of law by the concerned parties, and it is required to be given in the original form, original document. The court shall receive the documents so produced and such documents can be placed on record. Rejection of irrelevant or inadmissible document. If that documents are not relevant, why the court will keep? Court will reject that document. Rule 4 to 7, endorsement on documents admitted in evidence. If that document has been admitted in evidence, it will be exhibited by mentioning the number of title of the suit, name of the person producing the document, date on which it was produced, and a statement of its having been so admitted, it will be mentioned in the same. 5, endorsement on the copies of admitted entries in the books, accounts and records. 6, endorsement of documents rejected and inadmissible in evidence. If the court is of the opinion that the said documents are not required to be admitted, court will reject that document, and after doing that, court the statement of its having been rejected and the endorsement shall be signed and installed by the judge along with the earlier rule 4's requirement. 7, recording of admitted and written rejected document. At this stage, court will, whatever the documents has been admitted, will keep in the custody of the court, and the documents which has been rejected will return to the concerned parties. 8, court may order any document to be impounded. Notwithstanding anything contained in Rule 5 or Rule 7 of this order, or in Rule 17 of Order 7, the court may, if it sees sufficient cause, direct any document or book produced before it in any suit to be impounded and kept in the custody of an officer of the court for such a period and subject to such conditions as the court may think fit. If the document infringes any law and the court has having some reason behind it, court will pass the order and court will impound the said document. Return of admitted documents. I have told you if the document has been admitted, it will be kept in the custody of the court. At which stages it can be written of the admitted documents when where the suit is one in which an appeal is not allowed, when the suit has been disposed of, where the suit in one which an appeal is allowed, when the court is satisfied by the time. These are the stages after the disposal of the suit or the appeal. You have got the admitted documents, but on the return of document admitted in evidence, the receipt shall be given by the person receiving it. And if during pendency of it is required, by giving the undertaking that by affidavit that I will not misuse, I will produce the document as and when required, court will return the document. 10. Court may send for papers from its own records from the other courts. Provisions as to the documents applied to the material objects. These are the concepts with regards to the order 13, production, impounding and return of document. The original documents are required to be produced on record before framing of issues. It is the stage to produce original documents on record before framing of issue. Second thing, court may having power to admit, to reject and to return the documents produced by the parties. For that purpose, court will sign, court will ensure his signature and court will give the reasons for the said purposes with regards to the order 13. These concepts are there under the order 13, production, impounding and return of document, in which the rule 4 to 7 deals with regards to the admission of document, 7 and 9 return of document, rule 3 and 6 rejection of document, and rule 8 impounding of document. So this is order 13. After production of the document, what is the next stage of the suit? Next stage of the suit is the settlement of issues and determination of suit on issues of law or on issues agreed upon. Here only two terms are there: settlement of issues first, determination of suit on the issue of law or on issues agreed upon. It is the concept who may settle the issues, at which stage court may frame the issues. What the rule 1 states? Framing of issues. Issues arise when a material proposition of fact or law is affirmed by one party and denied by the other. One party asserts, another party denies, fact in issue arise. If one party asserts, another party supports. Yes, it is true fact. And there will be the fact in issue? No. Fact in issue will only arise when one party asserts and another party denies, fact in issue will arise. So it is the stage which is very important stage in the stages of the suit. And it is for the court to frame the proper issues for the right decision of the case. So issue, it means a point in question. And why it is important? If it decides in favor of the plaintiff, will in itself give a right to relief, and if decides in favor of the defendant, will in itself be a defense. Framing of issues: when a material proposition of fact or law is affirmed by one party and denied by other. What is the object of issues? To ascertain the controversy in the suit and rival contentions between the parties. What are the kinds of issues? Issues are of two kinds: issues of fact and issues of law, but sometimes mixed issues of fact and law, and the court should pronounce the judgment on all issues. Whatever issues framed by the court, it is the duty of the court to frame the to pronounce the judgment on all issues. But the court will try the issues first when it deals with regards to the jurisdiction of the court or a bar to the suit created by any law for the time being in force. What are the importance of the issues? The issues are the backbone of the suit. Issues are the backbone of the suit and court's power and duty as to the issues. It is the duty of the court to frame the proper issues, rest upon the court with due care, caution, and diligence, and understand the facts of the case before framing of the issues. Issues must be specific and clear and should not be vague or evasive. In framing of the issues, a great deal depends upon the literacy skill of the presiding officer. What skill he is having with regards to the framing of issues, it is the skill of the concerned presiding officer. What are the material which requires to be taken into consideration while the framing of the issues? That the allegations made on oath by the parties, pleadings of the parties, allegations made in the pleading, documents produced by the parties, all these things are required to be considered at the time of framing of the issues. Second thing, issues agreed upon. If the parties are such a way that they are agreed upon the issues, and only contention is that if they are execute the any agreement to that effect, that whatever the decision passed by the court will be binding upon them, and court is of the opinion that yes, whatever the agreement between the parties are in the bona fide nature, court will proceed to decide the said agreed issues as like that has been framed by the court. So the rule 1 framing of the issues, after perusing the all material propositions, those are propositions of law or fact, which the plaintiff must allege in order to show a right to sue, or a defendant must allege in order to constitute his defense. Issues are of two kinds, issues of fact and the issues of law. Court to pronounce judgment on all issues except when there is the objection with regards to the jurisdiction of the court or a bar to suit created by any law for the time being forced. Why? If after full-fledged trial it is found that that court is not having jurisdiction to try, or that has been barred by any other law, if the issue with regards to it, it can be decided by the court. Rule 3, materials from which the issues may be framed, allegations made on oath by the parties, allegations made in the pleadings, the contents of the documents produced by the either party. Court may examine witness or documents before framing issues. Court has power, if required, court may examine the witness or the documents before framing issues. It is the power vested with the court to amend and strike out the issues. The court may at any time before passing a decree. At which stage? At any time after the framing of the issues, but before the passing of the decree, court has the power to amend or to strike out the issues. 6, question of fact or law may be agreement be stated in the form of issue. That is the last part. If the parties to a suit are agreed as to the question of fact or law to be decided between them, they may state the same in the form of an issue and enter into an agreement in writing that upon the finding of the court in the affirmative or negative as such. And if the court is of the opinion that Rule 7, court if satisfied that the agreement was executed in good faith, may pronounce the judgment with regards to same thing. So the order 14, issues are the backbone of the judgment. So for the right decision, proper issues are required to be framed. If the issues goes in favor of the plaintiff, he will succeed. If it goes in favor of the defendant, defendant will succeed. Therefore, there are too much importance in the framing of the issues. So it is in the district judge main examination that there is the judgment for 30 marks. So if you in the written of at the time of writing of the judgment, on the basis of that fact, if you frame the proper issues in that answer, you will get the more marks. And in the practice also, if the proper issues are framed, there will be the right decision with regards to the said fact. So what are the next stages after the framing of the issue? The very little order, that is the order 15, disposal of the suit at the first hearing. Order 15 states party is not at issue. Court is of the opinion that no party is at issue. Why it is required to be proceeded? where the first hearing of the suit, it appears that the parties are not at issue on any question of law or fact, court may at once pronounce the judgment. When the several defendants not at issue, to that extent, when the parties at issue, and if the court is of the opinion that no further evidence is required, then court will proceed to pronounce the judgment and proceed to decide the said suit in the first date of hearing. Therefore, the order 15 itself sufficient to show that disposal of the suit at the first hearing. It only contains when the parties are not at all issues, the court may pronounce the judgment at once without waiting for taking the evidence or without leading by the evidence by the party. But if the suit has not been disposed of at the first hearing, then the next stage will come, that is the order 16. What is the stage order 16? The nomenclature of the order 16, the heading of the order 16 is that summoning and attendance of witnesses. Rule 1 states list of witnesses and summons to witnesses. On or before such day as the court may appoint, and not later than 15 days after the date on which the issues are settled. The parties shall present in a court a list of witnesses whom they propose to call either to give evidence or to produce documents and obtain summonses to such persons for their attendance in court. To the extent of order 16, you have to keep in mind, after the framing of issues, it is the stage to give the list of witnesses to the court within a period of 15 days. What the word has been used? Not later than 15 days after the date on which the issues are settled, parties shall give the list of the witnesses whom they want to propose as a witnesses. 1A, production of witnesses without summons, they may appear. Expenses of witnesses to be paid into the court on applying for summonses, because witness, whatever the bhatta of the witness is required to be paid by the concerned party who are calling them. Tender of expenses to the witnesses at the time of issuance of summonses. Procedure when insufficient paid, punadesha hai. Expenses of witness detained more than 1 day. Time, place, and purpose of attendance to be specified in the summons. When in order 5 we have discussed, the court will issue summons to the defendants for the framing of issues or for the final disposal of the case. In the summons for the witness summons, it is required to be mentioned for what purpose you have been called. It is for the production of the document or it is for the oral examination of the concerned party, and the time, place, and the purpose why you have been called is required to be given. Summons to produce document, which document you have to be come with that document is necessary. Power to require person present in the court to give the evidence or produce document. Rule 8 states summons how served. Every summons under this order, not being a summons delivered to a party for service under Rule 7A, shall be served as nearly as may be in the same manner as a summons to a defendant, and the rule in order 5 as to proof of service shall apply in the case of all summonses served under this rule. Whatever the rules of order 5, all are applicable to the order 16. Time for serving service of summons, sufficient time is required to be given. What is the difference in order 5 and order 16? If under order 5, summons has been given to the defendant to cause the appearance, and if he didn't appear, court will pass the ex parte order. But if the summons has been issued under order 16 for attendance of the summons for the witnesses and he remained not present, according to the rule 10, sub rule 3, in lieu of or at any time issuing such proclamation or at any time afterwards, court may in its discretion issue a warrant either with or without bail for the arrest of such person, and may make an order for the attachment of his property to such amount as it thinks fit, not exceeding the amount of the cost of attachment and or any fine which may be imposed under rule 12. Meaning thereby, if you are party to the proceeding and remain absent, order will be passed against you, but no warrant will be issued against you. But if he is the material witness and despite the service of summons, despite the proclamation, if he avoid to come before the court of law, then court may issue the warrant with or without bail, or court may attach the property of the concerned witness. If witness appears, attachment may be withdrawn. Procedure: if witness fails to appear, court may attach the property, and if he fails to appear, court may sole out. The mode of attachment as like the execution proceeding. These are the some of the rules with regards to the Order 16, that is summoning and attendance of the witnesses. Order 16A deals with regards to the attendance of witnesses confined or detained in prison. If it is detained in prison, now it is very easy task to take the evidence on the basis of video conferencing. So on the VC, evidence can be taken, but Order 16A deals with regards to the said attendance of the witnesses in prison. Order 17 is the very short order which deals with regards to the adjournment. So the Sunny Devil states Tariq pe Tariq, Tariq pe Tariq, Tariq pe Tariq. We have to keep in mind, in view of the Order 17, no such adjournment shall be granted more than 3 times. So therefore, maybe the Sunny Devil will state 3 times as a Tariq pe Tariq, Tariq pe Tariq, Tariq pe Tariq. In Order 17, you have to mention no adjournment shall be granted more than 3 times. Cost of adjournment, grounds of adjournment, you have to state it specifically. On fictitious grounds, court will not grant you the adjournment. Now the moving next stage, that the next stage is only now the 2 orders remains. Order 18, hearing of the suit and examination of witnesses. According to the Order 16, we call the witnesses to appear before the court of law to give the evidence. Who may right to begin? According to the Rule 1 of the 18, plaintiff has the right to begin unless the defendant admits the facts alleged by the plaintiff and contains. So, according to the Rule 1 of the Order 18, the plaintiff has the right to begin for leading the evidence. Statement and production of the evidence. So evidence, there are several issues. The sum of the issues can be evidence can be lead thereafter. Party to appear. Rule 3A is the important. It states party to appear before other witnesses. Where a party himself wishes to appear as a witness, he shall so appear before any other witness on his behalf has been examined, unless the court for the reasons to be recorded permits him to appear as his own witness at the later stage. Whoever party to the proceeding wants to examine himself may request to be firstly appear and examine, and thereafter other witnesses can be examined. Recording of evidence. How to record the evidence? As per the rules, whatever the examination in chief of a witness shall be on affidavit as per Order 19. Copies there are required to be given to the other side, and it will be the evidence, that is the cross-examination and re-examination of witness in attendance, whose evidence examination in chief by affidavit has been furnished to the court, shall be taken either by the court or by the commissioner appointed by it. And for this commissioner, whatever the rules of the Order 26 and Section 75 will be applicable here also. How evidence, Rule 5 states, how evidence shall be taken in appellable cases? In writing by or in presence of or under the personal direction or superintendence of the judge, or from the dictation of judge directly on a typewriter, it can be taken. When depositions to be interpreted, evidence under Section 138, memorandum when evidence not taken down by the judge, when evidence may be taken in English. These are the processes or the procedure for the taking evidence. When there is the, according to the Rule 12, remarks on demeanor of the witness, the court may record such remark as it thinks material respecting the demeanor of any witness while under examination. 15, power to deal with the evidence taken before another judge if there is a transfer or any count that can be read. According to the rule 16, it is the power to examine the witness immediately if it is some of the fear that where the witness is about to leave the jurisdiction of the court or other sufficient cause, court has the power to examine witness immediately. 17, again the power of the court to recall and examine the witness. 18, power of court to inspect, and 19, power to get statement recorded on commission. So Order 18 deals again with regards to the two propositions, that hearing of the suit and examination of witnesses. Whoever witnesses are required to be examined. Prior to examination of other witnesses, the party himself is required to be examined. Who has a right to begin? Plaintiff has a right to begin with regards to the evidence. Then he will file the evidence plus process. Then the defendant evidence will be started. Same thing with regards to the hearing of the suit. Plaintiff has a right to begin, and then after defendant, court will hear the matter. Court will do whatever exercise will require. Court will the court has power with regards to the examination, re-examination, calling of the witnesses to not been given by the party. All the power are vested with the court. This is what the order 18 deals with regards to the hearing of the suit and examination of witnesses. The order 19 deals with regards to the affidavits. Rule 3, matters to which affidavit shall be confined. Affidavit shall be confined to such facts as the deponent is able of his own knowledge to prove. Only to that extent that affidavit can be filed. Power to order any point to be proved by the affidavit that deals with the court, and after the amendment, every chief examination will be on the affidavit. The provision of order 19 deals with regards to the affidavits. Now, it is the last stage of the suit, that is the order 20 and section 33, which deals with regards to the judgment and decree. So, section 33 reads judgment and decree, and at which stage court will pass the judgment and decree. The court, after the case has been heard, shall pronounce judgment, and on such a judgment, a decree shall follow. After 33, there is a section 34, which deals with regards to the interest part, and 35 deals with regards to the cost, 35A, compensatory cost, and 35B, cost for causing delay. Now, this is the link to the order 33 and section 33 and order 20, judgment and decree. What the rule 1 states: judgment when pronounced. When the hearing has been concluded, the duties of the advocates and duties of the parties has come to an end. Now it is the duty of the court to pronounce the judgment, to draft a judgment, to prepare a judgment. Judgment when pronounced. The court, after the case has been heard, shall pronounce judgment in an open court, either at once or as soon thereafter as may practicable, and when the judgment is to be pronounced on some future date, the court shall fix a day for that purpose, of which due notice shall be given to the parties or their pleaders. It is the stage after the case has been heard, the court shall pronounce the judgment in the open court. Rule 2, power to pronounce judgment written by the judge's predecessor. If the earlier predecessor has written the judgment, but if he has not pronounced, then the next judge will pronounce the said judgment. Judgment to be signed. Every judgment shall be dated and signed by the judge in the open court at the time of pronouncing it, and when once signed, shall not afterwards be altered or added to, save as provided by the section 152 or a review. Once the judge signed the judgment, he cannot alter or then change it. Judgments of the small causes courts, judgment of the other courts. Rule 5, court to states a decision on each issue. On what basis court will give the decision? Court to state its decision on each issue. For each issue, court shall give the reasons. 5A, court to inform parties or where an appeal lies in case. If the any party has been pleading in party in person, court will inform that where the appeal will lies against the said judgment. Contents of decree. Rule 6. The decree shall agree with the judgment. Decree shall agree with the judgment. It shall contain the number of suit. Whatever the requirement of the judgment, it shall contain the number of suit, names and description of the parties, their registered addresses and particulars of the claim, and shall specify clearly the relief granted or other determination of the suit. 6A. Preparation of the decree. After passing of the judgment, it is the duty of the court to prepare the decree. What should be the date of decree? It will be the question for MCQ. Decree shall bear the day on which the judgment was pronounced. Whatever the day on which the judgment was pronounced, the same will be the date of decree. 8. Procedure where judge has vacated office before signing decree, predecessor will sign it. Decree for recovery of immovable property. Decree shall, whatever the contents which are required to be mentioned in the plain, when the property is immovable property, description of that property, where it is situated, which can be specifically identified, all the things are required to be mentioned in the decree. Decree for delivery of movable property in the same manner. Decree may direct payment by installments. 12. Decree for possession and lease profits. What the ingredients which are required to be mentioned when the decree for the possession and the lease profit. 12. A decree for specific performance of contract or for the sale or lease of the immovable property. 13, 14 and 15 with regards to the decree in administration suit, decree in preemption suit, decree in the suit for dissolution of partnership. 16. Decree in suit for account between the principal and agent, special directions as to the account, decree in suit for partition of property or separate possession or share therein. 19. Decree when set off or counter claim is allowed. Where the defendant has been allowed a set off or counter claim against the claim of the plaintiff, decree shall state what amount is due to the plaintiff and what amount is due to the defendant, and shall be for the recovery of any sum which appears to the either party. Appeal from decree relating to the set off or the counter claim, and after doing all these exercise, certified copies of the judgment and decree to be furnished to the concerned parties. Certified copies of the judgment and decree shall be furnished to the parties on application to the court at their expenses. So, for the Order 20, Section 33 judgment and decree, we cannot elaborate more apart from it, for the reason that after the case has been heard, it is the duty of the court to pronounce the judgment at once in the open. What are the essential ingredients which are required to be mentioned in the judgment? That the name of the court, name of the parties, the day on which it has been pronounced, and in the format of judgment, whatever the pleadings of the parties, what the issues has been framed, and then the reasonings for the issues, and then the operative order, whether the suit has been dismissed or decreed. All these things are required to be mentioned. Order 20A states with regards to the cost, whether to whom may be required to be paid the cost, and here we have concluded our first part of the Code of Civil Procedure, which is for our convenience, that is from Section 1 to Section 35 and Order 1 to Order 20. So, to summarize today's lecture, I will told you as like in the story from Order 1 to Order 20. Take into consideration for institution of the suit, 4 things are essential. The first one is the opposing parties. Second one is the subject matter in dispute. Third one is the cause of action. And the fourth one is the relief claim. To fight, or if there is the fight, there should be the 2 parties. Therefore, Order 1 deals with regards to the parties to suit. For the proper adjudication, necessary frame is required. Therefore, Order 2 deals with regards to the frame of suit. For doing a proper frame, recognized agents and the pleader is required. Therefore, Order 3 deals with regards to the recognized agents and the pleaders. Order 4 deals with regards to the institution of suit along with Section 26. Order 5, after presentation of the plaint, if it has been duly registered, court will issue summonses to the defendant for the service of summonses upon the defendants, giving notice, giving intimation that such and such suit has been filed against you and you may call the appearance. Order 6, 7, and 8 teaches us what should be our pleading. In the pleading, we have to mention the material facts, contains and contains only the material facts, not the law, not the evidence. Whatever the rules of pleading, Order 6 is applicable to Order 7 plaint and Order 8 written statement, set off and counterclaim. Order 7 gives us the knowledge with regards to the pleading of the plaintiff that may be called as plaint. What are the essential ingredients to be mentioned in the plaint and what is the consequences if it has not been mentioned? Plaint, return of plaint, rejection of. Order 8 deals with regards to the pleading of the defendant by virtue of taking defense against the plaintiff's plaint, that is the written statement. Along with the written statement, party may, if the suit is for the recovery of money, party may claim set off. In addition to it, the party defendant may file the counterclaim against the plaintiff. Order 9 gives us the knowledge with regards to the appearance of the parties and consequences of the non-appearance of the party. If the plaintiff remain absent, suit will be dismissed in default. If the defendant remain absent, suit will be decided ex parte. And Order 9 itself gives the reliefs for application for the restoration of the said DID order or the application for setting aside ex parte order. Order 10 is the stage wherein the court will firstly look into the pleadings of the parties and to ascertain the allegations between the parties and refer the parties to the mediation by virtue of section 89, that is the heading examination of parties by the court. 11, discovery and inspection. 12, if there is the admission, fact admitted need not be proved. According to the rule 6 of the order 12, court will pass the judgment on the basis of admission. If there is no admission, next stage will come into the picture, that the order 13, production, impounding and return of the document. Whatever the documents relied upon by the parties shall give the original documents before the court of law before the framing of issues. Before touching to the order 14, parties are required to produce the original documents on record. Court may admit, court may reject, court may return, court has a power to impound the document. Order 14 deals with regards to the settlement of issues and determination of suit on issues of law or on issues agreed upon. Issues are the backbone of the suit. For the right decision, proper issues are required to be framed. Entire decision is solely based upon the issues. If the proper issues are framed, there will be the right decision. If it goes in favor of the plaintiff, plaintiff will succeed. If it goes in favor of the defendant, defendant will succeed. Order 15 states with regards to the disposal of the suit at the first hearing. If the parties are not at issue, court will decide the said suit at the first hearing. If not decided at the first hearing, Order 16 will come into the picture, that summoning and attendance of the witnesses after the framing of issues not later than 15 days. It is the duty of the parties to give the list of witnesses to be examined by the court of law. All the provisions of Order 5 is applicable to Order 16 for summoning and attendance, except if despite the notice has been served duly upon the witness is not appeared, court has the power to issue a warrant, bailable or non-bailable, and also to attach the property of the concerned witness. Order 17 deals with regards to the adjournment. Order 18, hearing of the suit and examination of witnesses. It is the last stage upon the advocates and the parties to examine the parties and hearing of the suit. Order 19 deals with regards to the affidavit, and the last stage upon the court to pass a judgment and the decree whatever the suit which has been heard. So the entire proceeding started with the presentation of the plaint with preparation from the parties to the suit will comes to an end with Order 20, that is the passing of judgment and decree. So today we will conclude our from Order 1 to Order 20, and from Section 1 to section 35 of the Code of Civil Procedure. So I thank you.
Thank you, sir. Good evening, friends. At the outset, I sincerely thank Shri Sandeep Munde sir for today's clear and insightful session on the Civil Procedure Code. Despite his busy schedule, sir is taking out his valuable time for us, and his simple, exam-focused approach is truly helpful for all aspirants. I also thank all the participants for joining this fourth lecture with great interest. Friends, we all know that Sir has already assured us that he will complete the entire civil procedure code in this lecture series. In persons to that, the next session will be held on Monday at the same time. Thank you all. Good night and Shubharatri.
Thank you.